All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Welcome to the Court of Appeals. This is Arizona Court of Appeals, cause number CV130189. Kelly's versus United Heritage. Kelly's, is that correct? Welcome. For your information, these proceedings are being recorded both audio and visually. So hopefully in a couple of weeks you will be stars on YouTube, and you will have your 20 minutes of fame. As you approach the podium, which has a time clock on it, please identify yourself and who you are representing. Each side will have 20 minutes, and appellant, you may reserve a portion of your time for rebuttal. If you'll tell us how much time you want when you come up to the podium, we'll try not to horn in on your time. We have discussed the case in conference this morning. We have read the briefs, looked at relevant portions of the record, so we are familiar with both the facts and the issues before us. So with that, you may begin.
Good morning. May it please the court. My name is Steve Dawson, and along with my co-counsel Steve Kerman, we are here on behalf of Mr. and Mrs. Callies, who are the plaintiffs below and appellants in this court. There's a single issue before you today, I guess the possibility of a second one, the non-convenient forum argument, but primarily choice of law is what I'm going to be addressing, and I do plan on reserving 3 to 5 minutes for rebuttal time. The choice of law issue in this case and the facts that give rise to the choice of law issue they're all answered, but for the possibility of one fact by the Supreme Court's analysis in Bates versus Superior Court. There, the Supreme Court tells us that the analysis for an insurance first-party bad faith multi-state case is governed by the Restatement Conflict of Laws, sections 145 and 6, and that we are attempting to determine the most significant relationship to the parties and the occurrence, really as in every conflict of law analysis that we're dealing with. That the analysis is qualitative rather than quantitative, and that the place of injury becomes the presumptive choice of law. That was true in Bates, as it is in other personal injury cases. And place of injury, we see from the Supreme Court's most recent pronouncement on choice of law issues in Pounders, is where the last event necessary for liability occurs. In this case, clearly, Arizona.
What about the situation where the injury is continuing in terms of damage accruing and treatment required for that? I mean, I understand the alleged effects of the bad faith have accumulated or continued after the Callies have moved back to Oregon.
United Heritage refers to this as a transitory injury, and I assume, Judge Winthrop, that's what you're referring to. But the place of injury, of course, is a term of art, and it is a particular place. It's like domicile. You can only have one at a time. The place of injury denotes that place where actual and non-speculative damage has first been sustained.
And how do you define that, counsel? Point of injury. What is that element where the injury was first sustained? Where did that occur?
In our facts?
How do you define that injury? What is the injury?
The injury, as is often the case in a tort of first-party bad faith, is the deprivation of benefits as you're promised under the policy, and the resulting harm that flows from that. In this case, for example, we had the Callies who are waiting and waiting and waiting for this claim to be handled and have been assured that it's just a matter of whether we're going to give you this much money or that much money. As a consequence, are sitting on very austere living circumstances in their new home, their new retirement home. And they've had, keep in mind too, and this is often the case where they talk about one reason that insurance bad faith is recognized as a tort is the insurance company can become a second source of injury because courts have recognized you already have had loss and you're in a vulnerable position at the time you're submitting a claim. That was true for the Calleys. Having all of their property stolen was very devastating for this retired couple, especially given some of the things that were in it. Plus, they've just made this move from Oregon to Arizona, having sold all their property, their house, and their cars, and they really uprooted their lives to take up a new residence here.
So what was the last event necessary?
The last event necessary was the conversation from the United Heritage claims adjuster with first Mrs. Calleys, and then Mr. Calleys said, "Give me the phone." Then Mr. Calleys, when she informs the couple that rather than that check coming as had been promised, they are now the targets of a fraud investigation.
And where did that call occur?
That call came from the home office of United Heritage in Idaho to Arizona.
Thank you.
To Surprise, Arizona. At that point, Mr. Calleys' change in behavior became marked, and he started on this downward spiral from that point forward, whereas we've indicated in the complaint, he ended up actually being involuntarily committed because he became suicidal and homicidal. So the point of the place of injury, as place of injury is defined, was sustained in Arizona. That's the last act necessary for liability. So the only reason that I think that we're here is because after all of this happened, Mr. and Mrs. Calleys, well, actually it's Mrs. Calleys, because her husband was of no use any longer given the condition that he was in, made the decision to go back to where they had lived for so long in Oregon, where they could live for free in a little apartment behind their son's house. They put the Arizona home up for sale, and where she would have a more familiar network of doctors to try to decide what to do with her husband. If you look at the case law in terms of what impact does that have on the analysis, on the choice of law analysis, I submit the answer is none, because for it to have any impact, to suggest that it would have impact, really would fly directly in the face of the fundamental policy that both Arizona and the restatement talk about wanting to prevent, and that is forum shopping. If after the tort is complete, injury sustained, the act has occurred, now the cause of action can be brought, if courts are going to allow an injured plaintiff in that situation to stop and look around and move to a different state, and then from that state decide that suit's going to be filed, and that state's law is going to apply, well, the problems, the evils that would flow from that would be apparent. So I go back to Bates. Bates ended up concluding by saying, we reject the argument that the law of the state where the insurance contract was made must be applied to a bad faith claim arising from an accident in a different state, especially where the alleged bad faith conduct and resultant injury also occurred in different states, and the insurer does business in those states. All of those facts exist here, and in addition, we have the fact that the insured risk was in Arizona. It went from Oregon to Arizona with the blessing of United Heritage and the knowledge of United Heritage. And we have that the loss itself that gave rise to the claim occurred in Arizona. So you have Arizona residents, Arizona insured property, a loss that triggered the claim to begin with. The claim is adjusted in Arizona. Bad faith is committed in Arizona. injury is suffered in Arizona. It just does not strike one as the more complicated, nuanced choice of law problem that the courts have ever seen. To go back to Oregon after all this has occurred, for that to really factor into the analysis, you can find case law where courts have said place of injury we are going to give less weight to than is typically done, where typically it's the presumption that state's law will apply. In those instances when that's happened, the courts have found the place of injury to be fortuitous. And indeed, that's what United Heritage is arguing here. Well, the place of injury is fortuitous, and I understand why they argue that, because they're trying to thread this needle that they're trying to fit into this exception where place of injury is not given much weight. And if place of injury happens to be fortuitous, then they can try to come under the cases where that has been found to be the case. But place of injury, in no case that I have found, has ever been found to be fortuitous, where the place of injury was both the resident of the plaintiff and as well was the place where the act that caused the injury had its impact on the plaintiff in that same place. You had fortuity of place of injury in cases like the orthopharmaceutical case, Beraldi, where the plaintiff was in North Carolina as a temporary military assignment. It was not their domicile. They had not intended to make it their residence. Court found place of injury to be fortuitous. In the Garcia case, where you had parties traveling from one state through another state with the intention of going to a third state and an accident in that interim state, place of injury there was found to be fortuitous. The Pounders decision also kind of sheds light on this too, where there was a discussion about, in that case, between the Court of Appeals and then the Supreme Court's decision as to where was the place of injury. Mr. Pounders, while working in New Mexico, was exposed to the asbestos dust that later manifested after he had moved to Arizona, and when years later he became ill. One side argued that, well, the place of injury really was New Mexico, so that should be the presumption of whose law applies, because that was when he really did sustain the injury. The Arizona Supreme Court said, no, the place of injury is in fact in Arizona because it is the last act necessary to give rise to the cause of action. Going back to the original restatement before it was amended, that really was still the intent for place of injury. And Mr. Pounders or his wife couldn't have sued at the moment he came in contact with the asbestos years earlier in New Mexico. However, the court went on to find, but we're going to give less weight to place of injury because it really is fortuitous, because once the impact of the wrongful conduct, or stated better, once the wrongful conduct impacted Mr. Pounders in New Mexico, the chain of motion had been set. Mr. Pounders then could have chosen to move to any state. So place of injury and, in fact, place of residence for Mr. Pounders, the Supreme Court found to be fortuitous. So it placed much less emphasis on those factors than normally is done. And instead then looked to where did the bad conduct occur, which was New Mexico. Finding New Mexico somewhat dominant, then went to the Section 6 restatement factors and found the competing interest between the state, the two states, New Mexico and Arizona, to really change the outcome. So, I mean, all of these cases, you have to have fortuity before you're going to not give the weight to place of injury, as the restatement and our case law says. And the fact that the residency of Mr. and Mrs. Cowley's may have been of short duration doesn't change the fact that they had made the decision, they had taken all the necessary steps to become residents of this state, and were residents at the time. And If there aren't any questions, I'm going to reserve the rest of my time.
Okay, thank you, counsel.
Good morning, Your Honors. Neil Thomas on behalf of United Heritage. This is a bad faith case in which we agree the analysis is on choice of law. We might not agree about a lot of the facts that Mr. Dawson just suggested. I mean, not facts or analysis. But what we probably can agree on is Bates and Pounders together controlled this case because it sets forth 145 in the Section 6 factors. I say probably, because the essence of this argument is, are we going to apply contract law or are we going to apply tort law? We're sitting in Arizona, and Arizona recognizes the tort of bad faith. Interestingly, this is a claim in which there was an investigation of a loss, which the insureds were openly communicated was subject to a fraud investigation, and theoretically, that sent one of the two insureds off the deep end into a mental state that caused ultimate commitment. An investigation. It was a phone call. We're investigating you, and the rest falls from there. And from that, we get off into what I call the somewhat ubiquitous and not necessarily detailed argument on what the place of injury was. Remember, this was an Oregon policy for Oregon property with Oregon people that chose a state. Interestingly, these Oregon people forum shopped by suing here to seek a tort remedy.
Didn't they in fact forum shop by filing suit in the state in which they then resided? They bought a house here.
Now, I understand they bought a house here, but they filed from Oregon, living in Oregon, identified themselves as Oregon residents, and it never occurred to them to sue an Oregon company, an Oregon insurance policy written in Oregon for Oregon property. In Oregon, they came here.
Okay, hang on. Written for Oregon property. It was my recollection that the policy says that it covers their property anywhere in the world.
Absolutely, and that's part of the fortuity. If this had occurred as a theft in Nevada, and they made their claim when they got here, or they made their claim and then they got here, what are we talking about now? That transitory notion of this tort is particularly important. I agree with you that they lived here or were moving here. They were in a motel when the items got stolen. They were in a residence when the claim got adjusted. And the residency issue, just like the place of injury, is fairly fortuitous in this injury. And I understand the discussion about the last event to create the tort. Well, this whole tort is the issue. We assume for the purposes of the argument there's a tort because Arizona cares if there's a tort. But I don't think we can assume that because the plaintiffs choose to say the last event for the injury was a phone call, as opposed to, what really hit him was when he had to be committed, one of the two. Then it's in Oregon. This transitory nature of the tort is particularly important here. But we have Pounders. Pounders tells us the place of the injury is not dispositive. In fact, it was ignored in Pounders. And the plaintiffs have sat up here and suggested and used almost their entire argument to discuss this place of the injury. They didn't talk about the other three factors. And in Pounders, the court said, yep, you got mesothelioma, and accepted a petition for review solely to discuss the place of injury component, and then affirmed the trial court and affirmed the Court of Appeals that, guess what? New Mexico law applied because they had an interest. You go down the same components here that you do in Pounders, and I didn't get the chance to brief Pounders because Pounders was decided about 3 days after I filed my answering brief. And if you'd like a written response, I'd be happy to give it to you. I don't think it's necessary. I think it can be dealt with here. Pounders starts off with the place of the injury, and we have a problem with that in the context of this bad faith case. But we can presume it was the place of the injury if the court would like to decide so under the Pounders analysis. The next question is when you get into the second component, and the second component relates to excuse me, make sure I get them in order. Whereas where the conduct causing the injury occurred. The conduct was the adjustment of a claim and expressly alleged to be a phone call from an Oregon attorney to here. That's They want to talk, and the plaintiffs and the appellants want to talk about this place of injury, and in the complaint, they make it clear. An attorney called us and told us, well, then we're done. We also wrote a letter from Oregon that said, we want to take your EUO. And it took the insureds 4 months to have one of the two, not the other one, appear. In September, they didn't appear till March, so the claim is waiting for an EUO. The conduct, just as it was in the Pounders case, emanated and was from the actions of the Oregon adjustment of this claim, but the attorney who was responsible for it. Not any more significant than being exposed to the conduct that created the asbestos-related disease in New Mexico. The next issue was the domicile and the residency, which the court punted on. It said, no, it's not particularly important. It doesn't matter in Pounders because it is transitory and it doesn't really matter. Then the last one was where the relationship centered, and the trial court found the relationship centered in Oregon. It was just a fleeting opportunity to pick Arizona. I mean, Arizona is pretty important in this case because A, this is where they did decide to move, and B, this is where they did decide to file. It'd be an interesting development to see what this would be like if they did decide to file where they were living at the time they filed their lawsuit, which was Oregon.
Doesn't it, it wasn't just the fact that they were wanting to sue in bad faith. They also have a claim against the lodge. And so they bring, it seems to me anyway, it makes sense to file in Arizona because the lodge is never going to, Oregon is never going to have jurisdiction over the lodge. Clearly that's got to be an Arizona suit. And so the, I guess it really, it's not just that they were form shopping in my mind. In my mind, they were saying, where are we going to get, where can we resolve both cases in one? And that, to me, is Arizona.
Your Honor, we had a motion to sever pending in the trial court because I've rarely seen in my experience the tort bad faith claim appended to the underlying tort. In fact, I don't think there are too many cases that have, I couldn't find one where it was reported. And so the concept of, oh, they thought the lodge didn't give them appropriate premises liability protection, it would be no different than an automobile accident like any other case we ever talked about, like any other incident we've ever had occurred. The tort occurs wherever the tort occurs. The adjustment of the claim is the adjustment of the claim. The fact that what would we be saying to answer that question if the accident, the theft actually occurred in Nevada? They couldn't have sued in Nevada for the adjustment of the claim because it would have been either Arizona or Oregon. And so because the fortuitous event of the theft occurs in Arizona, in my view, bears no weight. They didn't see, and I overstate my case, I think, when I think it's blatant form shopping, but I think when Mr. Dawson and a very, very reputable bad faith law firm in this state looks into the issue, they know where they have to file a lawsuit if they want to seek tort damages because they can't get them in Oregon. In Nevada, what would the answer be if it was Nevada on the way here and it happened 24 hours earlier because their U-Haul was stolen somewhere else? That renders your argument quite fortuitous when you try to discuss the fact that they should be together. And I think the court was pretty inquisitory about that, but that issue never made it here because the court rendered it all moot because of the choice of law analysis.
So if the severance had been granted, then the choice would have been either separate litigation within the state of Arizona or the lodge being sued and the trial occurring in the state of Arizona while everyone then shifts up to Oregon and they try the second suit in the state of Oregon.
Not necessarily, Your Honor.
With the severance, what else could it have been?
Well, with the severance could have still been two separate litigations here.
That's what I said.
Yeah.
It's either going to be both of them sued in the state of Arizona, but in separate trials, so there'd still be the cost of two trials, or the lodge is sued in Arizona. You're arguing needs to be taken up to Oregon, so they litigate one lawsuit here, and then they all trot up to Oregon and try the second suit there.
It's two separate events and two separate claims. There's a tort of premises liability, just like there could have been an automobile accident in the streets of Arizona somewhere. And then it's the way the insurance company handled the claim. That claim, that tort claim, is going to be wherever the tort occurred.
But you don't have to have comparative fault in order to have multiple defendants.
You don't have to have.
You say that it arises from the same set of operative facts. I don't dispute
Oh, no,
that.
I disagree. It does not arise from the same set of operative facts.
You said it does not arise from the
Oh, okay.
same set of operative facts. So my question for you is that, or my thought is, you're suggesting, I think you're suggesting that because of the fact that these don't arise from the same set of operative facts, they ought to just naturally be severed anyway. Is that right?
Well, that issue is not before us. That part of our argument was these are distinctly different litigations. They should be severed. The actual motion to sever was filed by the Lodge. But that's not before you on whether the motion to sever is there. And I don't think that's a component, because from now on, just always join the underlying tort case with the underlying investigation claim, and we always have complicated insurance litigation and simple or complicated tort litigation always tied to the same jury. I've not once seen a case where they talk about what I think is being suggested, judicial efficiency, and not an argument that was particularly raised by the plaintiff.
Well, judicial efficiency is certainly an aspect of it.
Judicial, yeah, but
But the cost of the litigants.
The cost of the litigants are whatever the costs of the litigants are with a fairness of litigation. And I don't think cost of the litigants has ever been discussed as a choice of law issue. Choice of law issue goes to the most significant interests of each state.
Agreed.
So I think we're off on a tangent, because I think that issue is a red herring because it's not supported by any case law, to be clear and cogent about it.
Thank you.
Okay? So then the centered relationship the court found quite clearly was, the trial court found, and we agree, and there's been no suggestion that the centered relationship wasn't anywhere really other than Oregon. Of course, then we fall into the restatement 6 factors. The restatement 6 factors only allow to trump the conclusion from the restatement 145 factors if Arizona was to have a more significant relationship than Oregon. And Arizona's fleeting. Arizona's fortuitous. The place of injury, okay, if we concede, which I do not concede in this kind of bad faith case, I do not concede the place of injury is Arizona. Otherwise, we are subject to choice of law provisions by however a plaintiff artfully says, oh, the first event to cause bad faith occurred. This isn't the same thing as a gunshot wound or an automobile accident. The continuing transitory tort's important. A jury might, let's assume that we went to a jury on facts and we wanted special interrogatories, and we asked the jury, where did the place of injury occur? Because I'm going to keep a choice of law question alive, because somehow it's a question of fact as to what a place of injury is. And nobody suggests that the place of injury is anything but a legal question in this context when it comes down to it. But why wouldn't it be? And we would have a jury then say, well, the place of injury wasn't until after they moved back, when the insurance company just went too far. Everything they did reasonably, by telling them that we were investigating them for fraud, by taking their EUO, and then the facts developed. They never should have taken their EO, but they took EO, and EO is when the bad faith occurred, because you just went too far for this poor man. And now the place of injury is in Oregon, and all the argument we just had, which is the plaintiff's seminal fact, which they want you to assume that the place of injury is Arizona, would put the whole choice of law analysis flat on its head. Just put it right down in the prone position. It wouldn't be standing upright at all. And that's the reason that in the bad faith context, it's particularly important to deal with the general facts, not trying to deal with what the plaintiffs like to say is, well, we get to assume every fact we've ever alleged as being true. There's also a certain twist to this case. And that twist is, if they were in Oregon and they tried to apply Arizona law, I suppose Oregon would start their approach, because they also use the restatement analysis with, well, it's a contract case. Even though they're trying to plead a tort case. And interestingly, they didn't try to suggest that Oregon law should be expanded and bring this case to Oregon under the modern rubric of what we might call Arizona's bad faith, which isn't so modern, from Noble back in 1984. But isn't this really a contract case in its essence? And we don't have that situation arising in either Bates or Pounders. They talk about it being a tort case because that's what was filed here. But if this is an Oregon case, it's a contract case. And if you look to Section 93, it says where the contract was formed, and basically that's it. And then you go to the Section 6 rules to find out whether anything's trumped. And we've applied Section 193 in the context of contract cases and in UIM claims, and perhaps the UIM claim bolsters itself off into a bad faith claim because of the way it's been adjusted. But we don't have an answer on the Section 93 analysis that's here. And I would submit that just because the whether you want to call it forum shopping or ease of administration or whatever it might be. I would submit that when you come down here and you get to start off with the tort rubric, it becomes slightly more complicated, but in Pounders, we recognize that the place of injury is, as the plaintiffs would like this to be, and as Mr. Dawson first said, the be-all, end-all. It's one of the 4 factors before you get to Section 6. I would suggest that we're done with the Section 93 analysis because that's what this case is. This case relates to an Oregon policy for which there is no tort of bad faith in Oregon, and Section 193, if applied that way, which I think would go into the Section 6 analysis, because you're talking about the relevant policies of not only this state, but also the relevant policies of Oregon. So their relevant policies of, they negated the concept of bad faith and said this is a contract claim. And that's an overlay that goes into the analysis of the Section 6 factors, which I want to talk about briefly, but not incoherently. The Pounders Court pretty well said almost all of those factors don't apply. I think they apply a little bit more differently here. Sections, they talk about them as factors 1, 2, 3, and 1, 5, and 7 as not being applicable. And those factors are the needs of the interstate system, the basic policies underlying the particular field of law, and an ease of determination. They also say that the certainty issue is a forum shopping issue, and it's not an issue there. I think that it's clearly arguable that forum shopping is at issue here when you have someone who filed a lawsuit from another state. I understand in order to sue somebody wherever the accident occurred, they could have had an automobile accident in Tennessee, you're going to have to sue the tort victim in Tennessee. And suppose they were down here visiting and this happened, they went back home to Oregon. They're not going to be suing the lodge in Oregon. Then they turn into the other sections, and they basically say only 2 and 3, which are relevant policies of this state, relevant policies of that state, which I really just talked about, militated in favor of the policy of New Mexico. They acknowledge that tort victims have a right to be compensated in Arizona, but they also acknowledge that there are other policies more relevant that have more to do with the actual at issue in New Mexico. And so what happened in the New Mexico case? In the New Mexico case, they said an Arizona resident of long-time duration, which was Bates, by the way, an Arizona resident of long-time duration who was being paid for over 20 years, and then the claim, for lack of a better word, was readjusted. And when it was readjusted, they said, everything occurred here. All the medical treatment occurred here in Bates. All the emotional anguish occurred here in Bates. But that's not true in this case. In this case, medical treatment. We don't know of any medical treatment here in Arizona. We only know what they've alleged, that he was committed in Oregon. And they give their reasons of, they thought they were going to be here, that was easier to go back to stay. They suggest they couldn't find medical treatment, or they wouldn't feel comfortable with medical treatment in Arizona. That's pretty good thoughts for an Arizona resident to say, well, I'm an Arizona resident now, but I don't like anything they do here. I'll go back to Oregon. And I attached for your information the sheet that showed what was stolen. Almost all of their principal belongings, like bedding and beds and kitchens, all that stuff was sold in Oregon. They came down here with what we'll call choses in action, the stolen property, which was going to turn into money to replace the stolen property, but almost no necessities. And they give this argument of, well, we had to live uncomfortably in our house, when the things that were taken were things like guns and equipment and tools and things like that were in this truck. And so then we get right back to where I think we have to be a little less, I have to be a little more cynical as a defense lawyer, where it's, we're going to give this litany of all these things that occurred in Arizona to try to make Arizona the be-all and the end-all. And that's the argument you heard. Arizona's the be-all and the end-all. Pounders negated that completely. Pounders, in fact, the exact analysis of Pounders when it talks to the Section 6 factors and when it talks to the Section 145 factors so strongly militates this court has to find under the facts and circumstances of this bad faith case, the only component that's truly different, is here. It's here. It's not here in Arizona. It's in Oregon. If they wanted to bring a lawsuit, if they wanted to bring a law in Oregon, they probably could have said, well, maybe Arizona choice of law rules apply because they have a tort down there. That's where the first phone call came to us. And so this, in many respects, has more to do with where the lawsuit is filed because of the 145 versus the Section 93 factors than it does anything else. And that's why I think forum shopping has more to do with this than anybody wants to let on, because we all think that's sort of a poor thing for attorneys to do or whatever. Well, that's what good attorneys try to do. Bottom line, place of injury is not the be-all, end-all. This is an Oregon individuals with an Oregon policy, with property and belongings they had in Oregon. They came here. Arizona is a fortuity. Nevada could have been where the theft was, et cetera. I think Pounders basically controls the analysis. And with that, if you have any more questions, I'll be happy to entertain them.
Good
No.
timing.
Thank you.
Thank you.
Let me address a couple of points that Mr. Thomas raised. One, in terms of forum shopping sort of being in reverse that he's suggesting, brings to mind the Arizona Supreme Court decision of Jackson versus Chandler, where there was that suggestion that this was a matter of whether California's law, which had the shorter statute of limitations period, was going to apply, or Arizona's longer statute of limitations. The court said, we don't consider cases such as this to be cases of forum shopping. Jackson has obviously chosen the state with the longer statute of limitations, but this is the state where the alleged negligent conduct occurred, where the accident occurred, and where the injury was inflicted. That's not forum shopping. Further, we supplemented some authority yesterday, and the Arizona Supreme Court decision, whose name is escaping me right now, that I just supplemented yesterday, made the point there that the accident and injury had occurred in California, I believed, and the plaintiff thereafter came to Arizona, moved to Arizona and filed suit. And the court made the point that nothing has changed here, other than since the accident and before the suit was filed, you came to Arizona, and now you're seeking to avail yourself of Arizona law. There, the court held that not just was this a choice of law problem, but rather there was a jurisdictional problem, because there were not acts that had occurred in the state of Arizona that could give rise to the cause of action. That argument could be made here had the Callies decided to file in Oregon. What act gave rise to the cause of action that would give Oregon jurisdiction? And that also goes to Oregon's interest that Mr. Thomas was arguing. When you really look at what are Oregon's legitimate interest in this conflict, the answer is that there's no conduct in the state of Oregon for Oregon to have any interest in governing in this action. If Oregon has an interest to protect Oregon insurance companies from bad faith liability, since it doesn't recognize the tort, well, it has no interest in protecting United Heritage, which is domiciled in Idaho. That's consistent with the Arizona Supreme Court's analysis in Bryant. As a matter of fact, when the SunWest airline crashed in Colorado, where you had a plaintiff who was an Arizona domiciliary and SunWest was an Arizona domiciliary, it pointed out that the limitations on the tort claim in Colorado might benefit a Colorado corporation, but Colorado has no interest to an Arizona corporation in this case. Also then, in the Jackson versus Chandler case, the court discussed a Ninth Circuit case of Ledesma, where the choice of law would determine there whether California, Arizona's longer statute of limitations would apply. And in quoting the Ninth Circuit, the Arizona Supreme Court in Jackson said, California's interest in protecting its courts from stale claims is at least equally balanced by its interest in allowing its residents to recover for injuries sustained in a state that would recognize their claim as timely. This is not contrary to Oregon's interest, keeping in mind that we're really not talking about an Oregon resident, because residency is at issue at the time the commission of the tort and the injuries occurred. It is that an Arizona loss giving rise to a claim handled in Arizona, bad faith occurring in Arizona, injury occurring in Arizona, it's almost self-evident that Arizona law would regulate the handling of that claim. And to sort of underscore that, at the index of record 69, you would find United Heritage's response to our motion for reconsideration of the trial court's decision, where they argued at page 3, footnote 1, as this court is no doubt well aware, ARS section 20-466 recognizes that insurers that believe there may be fraudulent claims have an obligation to report such to the Arizona Department of Insurance. This footnote goes on, citing another Arizona statute in the Arizona Administrative Regulations for the governance of insurance claims handling, to suggest that they have a defense to their conduct in Arizona. My reaction is it's understandable that they would turn to Arizona law to look for a defense because, of course, the loss occurred in Arizona and the claim was adjusted in Arizona. But that, of course, goes both ways. The tort of insurance bad faith, Arizona has an interest in regulating conduct by insurance companies that take place in this state, especially against Arizona residents. And the only reason Mr. and Mrs. Cowleys were not Arizona residents at the time the suit was filed was because of the effect of the bad faith conduct upon them. They had chosen this place to retire and live out the rest of their lives and would be here but for this bad faith conduct. And I don't know where we've gone from a motion to dismiss to facts outside the complaint. Are we talking about a motion for summary judgment to now facts in the argument that you're hearing today that are not anywhere? But if we go back to a motion to dismiss, there really was no issue in the allegations of the complaint that could have even given rise to this argument. My time's up. Thank you.
Thank you, counsel. Thank you for your arguments. They've been helpful. We will take this matter under advisement and issue a ruling in due course. Thank you. We're adjourned.